But I also want to see if Monola will offer two, but Monola doesn't offer.
Okay, let's get started. And let me, as usual, ask where you are in evidence and whether or not today's subject has been covered yet in evidence, namely expert witness testimony in Rule 702. No.
Yes.
Yes? No?
Yeah.
Kinda? How many no's?
Oh, I know.
How many have not covered it yet? Okay. Everyone else has at least touched upon Rule 702 of the Federal Rules of Evidence. You may have also encountered some of this in first year torts with the Daubert opinion, which some torts classes covered. But it looks like the majority of you have at least some exposure to it. So, as we've been talking about throughout the course, a lot of the techniques that you will be using are tied to requirements in the rules of evidence. Perhaps none more so than direct examination of expert witnesses and tendering them as an expert witness and having them qualified as such and acknowledged as such by the court. So Rule 702, as most of you know, covers what is required in order for a witness to be deemed an expert at trial and designated as such. And there are two core showings under Rule 702. One is that you have to establish that the testimony is the product of reliable principles and methods. And then secondly, that the expert has applied the principles and methods reliably to the facts of a particular case in which he or she is testifying. Okay? So that requires a disciplined structure and content to your direct examination, more so than you would of a fact witness or a party witness. Because if you don't meet those requirements, the witness will not be allowed to testify as an expert at all. You're going to, it's going to be met with a lack of foundation objection from the other side. So structure and content is particularly important, and you have to keep the requirements of Rule 702 in mind. So what does that mean in terms of how do you structure your direct examination? Well, I'm going to go through various components of a direct examination of expert witnesses that I think meets the requirements of Rule 702. And I'm going to put it in the aforementioned block methodology that we talked about in just doing direct examinations in general of any witness, right? And we talked about the advantages of the blocking technique, where you break down your direct examination into discrete component parts, i.e. blocks, each one of which has a headline which introduces the jury to that subject matter, and then you transition from one block to the next with transitional statements as you move along. That works particularly well, and I think is an essential too when you're structuring your examination of an expert witness for the reasons that we mentioned, i.e. the critical need to meet the evidentiary foundation requirements of Rule 702. All right? So let's look at the blocks that you could use to frame your direct examination or structure it. Whether you use the block method or not, you are going to have to include most of these things that I'm going to talk about in a minute. But I think the block method really is helpful in that regard. So I have 6 blocks up here. The first one of which is the personalization block. Now, this is perhaps the most controversial in a sense, because what I'm recommending that you might do, and you please feel free to discard my recommendation, and the adjuncts may have a different view of whether a personalization block is either necessary or appropriate for an expert witness. We talked about its critical importance for other witnesses, right? Party witnesses, fact witnesses, whatever. It's certainly material witnesses. It has to deal with developing a rapport, personalizing the witness. That enhances their credibility. It increases the connection with the jury as a real life person, right? That same principle of likability and its connection to credibility, I think applies with equal force to an expert, perhaps even arguably more so, because the expert is a different type of witness, right? He's or she is going to be testifying about a lot of complex technical information, that creates a barrier, an additional barrier in and of itself. The type of information, the more formulaic way it's going to be presented. The jury is going to know that this is a different type of witness. So those attributes of an expert witness creates, I think, even a greater gulf of developing rapport with the jury, right? Likability means a lot in trials. In addition to having the facts and the law presented in the best light possible, the people who are telling the story and the people who are supporting the story, i.e. the witnesses, including the fact witnesses, if they can engage the jury on a personal level, where they are likable persons, that helps. I think it helps significantly. Now, this is a minority view, right? Most people will tell you it has no place in expert testimony. For one reason, it's irrelevant. Why is a guy or a woman's who's testifying as expert, why is there where they live, what their marital status is, how many kids they have, what their kids name? How is that relevant, right? So you could get a relevance objection under Rule 401. The response to that is that courts allow any witness to have some introductory biographical background information in order to allow the witness to or the jury to become acquainted with the witness, and that should apply equally to experts. However, some judges will say, no, this is not relevant, and they won't let you do it. Most judges will give you some leeway with at least perfunctory, introductory biographical background information. But the worst thing that could happen is that an objection of relevance is sustained, right? So what? All right, you move on to the heart of the testimony if that's the case. But I do think it's worth a shot. The other reason that some will argue that it has no place in direct examination, i.e. personalization, is that jurors are not interested in that. And I just think that's wrong. I think that overlooks and underestimates the role that likability plays in a juror's assessment of credibility. And so, if the expert lives and works in that particular city and, has 2 children, has been married to the same person, 2 school-age children, let's say, married to the same person for 27 years, that connotes that they're a regular person, first of all, regular guy or gal, right? That they are reliable, that they're stable. It just gives an insight into their character, which enables the jury to be more receptive to what they are presenting in their expert testimony. So you might, just to illustrate the personalization block, let's say it's Dr. Barron. Good morning, Dr. Barron. Will you please introduce yourself to the jury? By the way, I like, or again, this is me personally, a more personable type of introduction to any witness, as opposed to, please state your name for the record. That just sounds so cold, detached, you know, disinterested, I'm just doing this because I have to, you know, connotation to it. So, Dr. Barron, please introduce yourself to the jury. Okay, my name is Dr. Barron, blah, blah, blah. Now, doctor, before we get into your qualifications and your opinions, I want to ask you a few questions about your life here in Needham City, so that the jury can get to know you better. How long have you lived here, doctor? Whatever. Are you married, doctor? Whatever. What are the names of your kids? And the ages of your kids, doctor? Whatever the case may be in terms of background, biographical information that you think might be useful for this particular expert. Now, if he or she is a hotshot, you know, from New York and has no connection to the town, maybe you won't necessarily do that, right? And so you can play with how much, if any, of this personalization block you might want to include. But when you finish with it, like with any block, you let the jury know where you're going in terms of the next block. So thank you, doctor. Now that we know a little bit about you, I want to, and then we go to the next block, which is the preview question. Okay? Now, what is that about? You know, it's difficult enough for the jury to deal with expert testimony because of its technical nature. So they not only have to understand all that stuff, but they have to know exactly why the person is there and how it fits into the overall structure of the trial. You know, so they have to know why he or she is doing what they're doing. Because, you know, they're not like other witnesses, not testifying about facts. They're not party witnesses. You know, they're not eyewitnesses. So the whole structure and tenor of their testimony is going to be different from other witnesses. So you have to, I think it's helpful for jurors to get some help early on in the expert's testimony to help them understand you know, why the expert is testifying in this particular case. So the preview question is a very simple question. Let's take Dr. Rosenberg. Dr. Rosenberg, why are you here today? Now, obviously this is more important in a jury trial than a judge trial, right? But Dr. Rosenberg, why are you here today? Let's say he gives a response along the lines of, well, I'm here to testify to the conclusions I've reached about the cause and severity of plaintiff's epilepsy based on my experience and knowledge as a neurologist and my examination of the plaintiff's medical records. Okay, so the next question will be, doctor, before we discuss your conclusions, I would like to ask you some questions about what qualifies you to testify to those conclusions. That gets you right into the next block, which is an essential block in order to comport with 702, right? Professional qualifications block. So the preview question is a very good transition for the expert's qualifications, and it also gives the jury some context about why the lawyer is even exploring academic credentials or experience or professional affiliations in the first place. So the expert's qualifications are critically important. Why? And do not go through this block in a perfunctory, quick, sort of, you know, just disinterested way, right? This is a very important block. So it's important because, first of all, it's going to satisfy or help satisfy the legal requirements of Rule 702, at least the basic requirements, right? It also is going to, if you do it well, preempt an objection from the other side. And most importantly, it's going to build the expert's credibility as someone who's fully qualified to attest to the issues in the case, right? So, during that block, and I know it's, you want to get to the heart of, you know, what was your conclusion, but you got to do this and you got to do it well. So you want to show genuine interest in the background of the expert, right? And you do that through your body language, through voice inflections, through making eye contact with the expert, showing genuine interest in the answers, asking appropriate follow-up questions. So it's not like just I'm reading off a checklist of what I've got to do, right? You know the difference. Your cadence, your pace, even if the expert injects humor into the testimony, you need to laugh, you need to nod. You know, when the expert gives a particularly important part of their background and experience. That's what you should do. What you don't want to do during this, and what I think that the innate tendencies of most of us are, is to look away, shuffle papers while they're going through their their background, training, education, et cetera, or reading your questions from notes and then checking them off after they're asked and answered. You know, that sort of, all right, I'm doing this because I have to, it's just automatic. Or if you're maintaining a flat and monotone voice, you're just generally showing a lack, or communicating a lack of interest to the jurors while asking questions. Or you're asking the questions quickly, rat-a-tat-tat. You're not asking natural follow-up questions, and you don't have any particular regard for the answers. One answer is the same as the next. Oh, you've examined 2,500 patients with epilepsy. I think that's pretty important, right? You're Harvard-trained, Dr. Rosenberg. You're certified as a neurologist by XYZ certification bodies. I mean, you should react accordingly to the information being presented with the relative, level of significance given the testimony that's being given. Don't go through that in a quick and sort of, disinterested fashion for the reasons I mentioned. Natural follow-up questions will help, to convey that sense of high energy and importance that you want to communicate to the jury. Because they're going to take their cue as to its relative importance from what they see you doing, right? And if you kind of ho-hum, checking it off, looking at your next question, all right, I've done that because I had to. Let's get on to what his or her real opinion is in the case. So it's very important, I think, that you do it with vigor, with energy, and using all those non-verbal cues to let the jury know that what this person is saying is important and they're eminently qualified to say it. So you want to set that stage before they actually say what they're going to say in terms of their opinion. All right, so in the professional qualification block, that might be the best time to prick the boil, as it were, of the expert being paid, right? We all know that experts are paid for their time. We all know that's going to be one of the first questions on cross-examination. So, as with any other bias or unfavorable aspects of a witness's testimony, that would be the time to do it, and it would probably be towards the end of the qualification block, right? Because if you do the qualification block right, when you get to, who's paying for your time today question, it's like, well, he or she deserves whatever they're being paid to do this because they are so eminently qualified, right? So, the key point in this disclosure is that the compensation is for the expert's time, right? And not his testimony or her testimony. So that needs to be brought out. And that the payment of these fees were for his time and services. It didn't purchase a particular result. And, you know, it's to be expected that someone who is going to, you know, provide that kind of service or time, you know, is deserving of reasonable compensation. So that's the way to deal with it. That's the place to deal with it. And, you know, of course, as with any other negative disclosure, it enhances credibility when it comes from you, right? So that's it for the professional qualifications block. Now we're getting into the real meat of the testimony, you know, but again, it's important that you set it up properly. And the next step, or the third block here, or fourth block I have up here, if you choose to do the personalization block, would be the basis. So the basis concerns the facts and the data that support the expert's opinion. So before they can actually reveal their opinion to the jury, they have to explain the process by which they reached those conclusions, i.e. those opinions. And you should, that explanation of how they reached their opinion should cover both the general and the specific. Okay, what do I mean by that? So you begin by having the expert explaining the methodology or technique that they use to reach their conclusion generally. You know, what is the general method or technique used by experts in the field to conclude whatever it is, right? If it's causation of epilepsy, what do trained neurologists typically do? What is the general methodology and technique? And then you move to the specific. What steps did you take, Mr. or Miss Expert in this case, in reaching your conclusion, including any documents that they reviewed or analyzed, any tests that they may have conducted, any calculations they may have made. But in that basis block, you should begin with a general description of the expert's methodology and then move to a specific description of how the expert applied and used the methodology in this particular case. All right? So let's say you're going into the basis block for using Dr. Rosenberg. You may introduce that block with something along the lines of, now that we know about your education and experience, see it's coming right off the professional qualifications block, in neurology, I want to discuss with you in general terms how you go about the task of assessing the cause of epilepsy in patients. Can you describe for the jury the first step you take when you're trying to make that assessment? Okay? I'm just giving Rosenberg as an example. And then you go take him or her through the, all the steps. What's the next step? Why did you do that? What comes next? Whatever the natural flow of questions might be. So that's the general, right? Then you move to the specific. Now that we understand how you generally go about determining the cause of epilepsy, I'd like to turn to the specific work you did in this case to determine the cause of the plaintiff's epilepsy. How did you go about that task? Okay, so you're going from the general, how do y'all do it? How do experts do whatever they do to determine whatever it is they're determining? And what did you do here in this particular case? So from the general to the specific. Okay, so now we get to the main part of the show, which is the actual opinions of the expert. That's going to be the climax of the direct examination of the expert. So it's obviously the reason why you're calling this witness, and it is what you want the jury to hear more than anything else, right? And the probative weight that it's going to carry in the case is potentially, outcome determinative. So I think it's important to let the jury know what's coming and what's happening. So that's where you maybe change the tone or tenor or whatever in your voice. You lean into the witness. Use whatever hand gestures are appropriate. And you choose words that are going to unequivocally tell the jury that an important answer is about to come, right? So, it's typically going to involve a two-step sequence, two questions. The first question is going to ask whether they formed an opinion, and the second question is going to be, what is that opinion? It's as simple as that. Now, you don't have to use those words, but it's typically, traditionally going to have those two prongs to it, right? The opinion block. So, Rosenberg has a very impressive resume. Harvard, medical school, thousands of patients he's treated, I think, or examined with epilepsy, endless number of honors and certifications. And, so you would preface the opinion question with a lot of that information. Based upon your medical school education, your Harvard education in neurology, your residency at blankety blank, your fellowship wherever, the 2,500 patients you've examined with epilepsy. Have you reached a conclusion about Mr. Fulbright's epilepsy and the cause of that epilepsy? Okay, so that would be the way that you would get into the opinion block. And he'll say, yes, I have, and what is that opinion? Right? Not traumatic induced epilepsy, congenital, whatever the case, whatever conclusion that he's reached, it's all in the record. But that's the showstopper part of his testimony. And then the final block will be the reasons. Immediately following the expert's opinion, you should elicit the reasons for that opinion. Now, if at all possible, you should try to elicit that in a list format, right? Why? Because it's easier for the jury to remember. It's easier for you to structure and remember yourself, and it's easier for the witness to actually articulate, the 3 or 4 reasons for his or her opinion. Try to keep it to 3 or 4. If it's less than 3, it's not really a list, right? If it's more than 3 or 4, it's probably too many, and it defeats the purpose of, or the value of the simplicity of, boom, 1, 2, 3, maybe 4 tops, right? These are the reasons. Why have you concluded that Mr. Fulbright's epilepsy was not caused by the accident on July 20th, right? 4 reasons. Reason number 1, right? Reason number 2. It's very effective that way, and it's easy to digest, it's easy to remember, and it's easy for you to reiterate in your closing when you walk up to the easel and write those reasons down or project them up on the screen, however you choose to do that. Okay? But it simplifies it for the jurors, for the witness, and for yourself. So that's really a condensed and simplified structure recommended for a direct examination of expert witnesses. Now, again, your how-to book, the Loubet book, may give you additional information, it may give you alternative considerations, but most of these, if not all of these trial ad books, will have these elements somewhere in their recommended course of action. Okay? Any questions on that before we move on to cross? Let's see how we're doing for time. Okay, cross-examination of experts. Cross-examination is challenging for any witness, right? It's even tenfold when it comes to an expert witness. Couple of reasons. First, because experts are experts, right? They know more about this specialized field and have more specialized knowledge that they've accumulated over many years than you will ever know, right? So there's that. Secondly, good experts, many experts, are veterans in the courtroom. In fact, some of them may have more experience in the courtroom than you, especially early on in your career. So they're very comfortable, and they can be very difficult to pin down and control because it's not their first rodeo. Thirdly, they're usually very smart people, and they're articulate, and they're effective speakers most of the time. I shouldn't say most, but you should anticipate that they are going to be articulate, experienced, even charming, and comfortable in doing what they're doing, right? So that presents special challenges to you. But it's not something to be feared, and you should not fear it. It's just recognizing the characteristics of an expert witness and the phenomenon of cross-examining that kind of witness versus a regular witness. So, how do you deal with it? First of all, the way you deal with everything else that is going to ensure your success at trial. Dogged preparation, right? Knowing the facts, studying the field, your own expert work can assist you in that. Looking at the writings, publications of the expert that you're going to cross-examine, and finding every potential area of attack that you can, from just knowing the facts of the case, the particular field involved. It's going to be a quick study, and you're going to have to immerse yourself in it. But then, looking at what was produced by that expert in terms of other writings or conclusions in a particular case. There's plenty in the case file here for you all to work with, especially when it comes to what each doctor did or did not do in reaching their conclusions, both Dr. Barron and Dr. Rosenberg. If you know this case file, there's fodder for cross-examination of each of those doctors. And by the way, that's what you're going to be doing in this assignment on Monday, I'm sorry.
Tuesday.
On Tuesday, because Monday is a holiday and Tuesday is a Monday. For you adjuncts who may be looking at this, we have class on Tuesday because we're treating Tuesday as a Monday. So we'll do our performances. Those performances will include you're doing a direct examination of your doctor, plaintiffs, that means doing Dr. Barron, defendants, doing Dr. Rosenberg, and crossing the other side's doctor. Okay, so you need to prepare a direct and a cross. Okay, so how do we go into cross-examination? Well, first of all, cross-examination can provide, and this is something Professor Cialino talked about in cross in general, opportunities to buttress your own case by getting the witness to confirm key facts or propositions that are helpful to you. So it's sometimes best to begin a cross-examination of an expert not with impeaching or attacking their opinions, but with inquiring about areas of agreement, right? If there are any. Now, just off the top of my head, in this case, or in many cases, you can get the other side's expert on cross-examination to agree or recognize your own expert's qualifications, right? If you're cross-examining Dr. Barron, he can't really quibble with Dr. Rosenberg's very impressive resume, right? So you can get him to acknowledge that. Other areas may be getting them to admit that the facts that were relied upon, or the methods that were relied upon by your own expert were reliable or reasonable, right? And they'll usually have to conclude that the methodology was proper and correct, even though they disagree with the ultimate opinion that was reached. But my point is, you can get them to agree on facts that support your case. That's called constructive cross, right? But then you get into, inevitably, why you're cross-examining the expert witnesses, and that is to undercut their conclusions and attack what they have testified to on direct. So we have various areas that may be ripe for attack, depending upon the case and what the testimony was. But one may be, the first area may be the qualifications of the expert. Now, that could take one of two forms. One form could be attacking the qualifications with the goal towards excluding or precluding them from being a designated expert in the case. So, in that case, you want to undercut the entirety of their testimony because they're just not qualified to testify as an expert witness. That's one way or one potential area of attack. The other is the more frequently involved, and that is you're attacking the weight of the testimony that the jury should accord to that testimony, right? Now, in terms of the first type of attack, where you're trying to undo the purported expert, the putative expert as an expert, and get the court to sustain an objection of a lack of adequate foundation under 702. More often than not, that's going to be done in a motion in limine or a Daubert motion before trial, and it's going to be settled in advance. But there also is the technique of using a voir dire. Remember we talked about a voir dire of a witness for undercutting the foundation for a particular exhibit and taking the witness on voir dire? Well, that term also applies to experts, where you can actually attack their qualifications during a direct exam by cross-examining them during a direct exam on those qualifications. Now, you're not going to be doing that here. I just wanted to just give you an idea of the first type of attack, where you're trying to say this person isn't qualified as an expert. How exactly does that come about? So, getting back to the actual specifics, the qualifications is one area, potential area of attack. Dr. Barron has some issues in terms of his qualification as an expert because he's a family doctor, right? No training in neurology, and no special expertise. So he would be open to, I think, significant attack as to his qualifications to testify as an expert witness. So, you would show that whatever experience he has is beyond the scope, or what he's about to testify to in terms of the cause of epilepsy is beyond the scope of whatever experience he had in treating Jackie as a family practitioner. All right, so bias or prejudice, fees or relationships. The most common one there is going to be fees, and we've talked a little bit about, on direct examination, preempting that. But you still should ask that question on cross with sufficient follow-up questions and skepticism in your tone to suggest that they're just a hired expert Dr. Rosenberg, in that respect, has some problems, right? He's got, his nickname is Dr. Defense Verdict, always testifies for the defense, always reaches the same conclusion, defendant did nothing wrong, right? And is paid handsomely for being the hired gun that he is, right? So that's one of the more obvious areas of attack. There could be situations, although none are involved in this case, of relationships giving rise to bias. Maybe a tad with Dr. Barron. I mean, he's a family, he's treated Jackie since he was a little kid. Obviously, there is a relationship there where he may be inclined to give the testimony in light most favorable to help Jackie, a child he's treated all of his life, right? If there are any preconceptions, developed by the expert that, maybe you could ferret out from past testimony or past writings or statements that the expert has given. But I think the main ones for your purposes would be fees and or perhaps relationships, especially when it comes to Dr. Barron. All right, the basis can also provide a rich source of cross-examination material because the expert's opinion is only as good as the facts or the data upon which it is based. So you know the old axiom, garbage in, garbage out. That applies with the same force to expert witness testimony. So once you're able to demonstrate, if you can, that the expert has inadequate or unreliable basis for their opinions, then the jurors are almost certain to discount the actual opinion itself. So potential attacks on the basis might include unsupported assumptions or mistakes that were made or errors that were made by the expert or faulty preparation or faulty investigation, lack of personal knowledge, whatever you can use to undercut their purported basis for their opinion. And that's about it. Now, with cross-examination, as I said, of expert witnesses, you've got to be careful, and an expert, especially one like Dr. Rosenberg, in real life, is going to know a heck of a lot about the field of neurology, right? So you have to pick the areas of his conclusions and the underlying basis for his conclusions that are ripe for attack, and not just try to, undercut everything he concluded. There's enough material in the record, in this case, that can raise some questions as to the validity or the value or the weight of Dr. Rosenberg's conclusions, and there's certainly enough for Dr. Barron. I'm not, it's part of your job is to figure out what areas are ripe for cross-examination. But as with any cross-examination, it's even more important when an expert that you are very surgical in what you're attacking and that you're on solid ground with the weaponry that you were using for your attack, right? So all of these areas may not be in play. Right? Dr. Rosenberg's qualifications are impeccable. Dr. Barron's, there's some question. Right? They each have areas of weakness for their basis and their opinions, because the basis foundation is, in some parts questionable. The opinion itself is questionable. So that's your job, to figure out what those weak points are and exploit them on cross-examination. So what does that mean in terms of witness preparation? That means you got a bit of work to do, because if you're representing the plaintiff, you've got to be Dr. Barron as well. So you've got to be prepared to be Dr. Barron, to do the direct of Dr. Barron, and to cross Dr. Rosenberg. And the same thing on the other side with the defendant, right? This is only going to work, as these exercises do, as well as your level of preparation. So needless to say, there's a lot of medical terminology and medical tests and learned treatise information to review. It's not a lot in terms of volume, but it's technical, right? So it's going to take some work to get ready for Tuesday, not Monday. All right? Any questions on what we've covered today? All right. I look forward to seeing you on Tuesday.